Patent law enforcement. Today we're going to be covering a brief introduction of patents, patent laws, enforcement, patent laws in the digital age, independent invention and infringement, patent laws around the world, and an ethical analysis. Now, what is a patent? A patent is a section of the law that encapsulates the regulation and enforcement of certain laws that safeguard intellectual property rights. The laws are called patent rights, and they are applicable on an individual basis or in a group of people who have ideas that they want to keep to themselves as their property. Patent rights are granted to people for a limited period of time, in which their ideas can only be used by themselves or by their associates or any other person who they permit to use them. Patent rights implications vary from one nation to another, but the basic idea that the patentees protect their intellectual assets is the same in all countries. The enforcement of patent laws is one of the most challenging tasks in law, since it gives rise to many social issues. The patent laws are enforced in courts, and there are possibilities of penalties of those who break the law. Now, under the law, intelligence and information is treated as property, and it's what's known as a patent. A patent is normally in the form of a new invention or an idea that can either be used to make money by the inventor and others who have its access. In order to prevent the exploitation of one's intelligence by other people for their benefit, a person can pursue patent rights which protect his or her patent. Before people can be granted patent rights by their state, they must fulfill some requirements, including providing proof that the idea or intelligence they want to patent is their independent invention, and that the patent is original and worthy of the rights. When people acquire patent rights, they legally exclude other parties from reproducing their invention, using it or selling it for the given period of time that the patent laws apply to the patent. According to different states, patent rights may be revoked by a court of law if the inventor of a product fails to use the invention after patenting it. This usually occurs when other parties go to the court asking for the right to use the patented inventions. Patent laws may also be lifted if the idea is an improvement of someone else's idea. Normally, when people build on already existing ideas, they ask for permission from the original property holders to use their ideas. In some states, patent laws are addressed in a court of law. Civil courts handle infringement cases. Infringement is the breaking of other people's rights. Patent infringement is the access or use of patented property without the permission of the owner of the property. It is typical for the patentees to ask for compensation from the infringer. This normally occurs when the person has used the patented property for personal financial gain. In such cases, the court asks the person to pay a certain amount that is equivalent to the amount the owner may have accumulated if he or she was the one using the property. One of the greatest issues with patents is that they are territorial, meaning that the rights are only effective in the jurisdiction where they are given. A patent given in Canada, for instance, is only effective in that country. This means that anyone else who has come across with the idea can freely use it in any other nation. Patent laws can be traced down to the 15th century, when the first printer was produced. Over the centuries, the laws have become popular, especially in the 20th century when many technological devices and software were invented. In the current times, people invent new things on a daily basis. In the past, people would invent things and keep them secret so that others would not use their ideas to benefit themselves. People would die with their ideas instead of passing them on to the next generation. The fear of losing one's idea was eliminated by popularizing copyright and patent laws. In the digital age, many gadgets and ideas are invented regularly, and inventors are entitled to patent rights, which restrict the use of their inventions for a given period of time before the rest of the community can use the inventions for commercial purposes. Patents have a particular ethical handle in the digital world. They allow the inventor to monopolize their products for some time before the rest of the people can work with them. In the digital world, progress cannot be made if the researchers are working from scratch. They have to be given a starting point to build on. If a new gadget is invented by a technology researcher, for instance, other researchers may step in and attempt to improve the idea in order to come up with a more sophisticated gadget. So, in a hypothetical situation in which there were no patent rights, inventors would be forced to hide their ideas from the rest of the people that they work with to make sure their knowledge doesn't get out there. Now, patents ensure that the inventors are able to safely broadcast their ideas and keep track of their ideas for a substantial amount of time, after which the rest of the people can add their ideas and come up with other products. So, in this way, patent rights give room for progress in the digital world. Now, when someone comes up with a completely new idea or product, the idea is an independent invention, and the person may file for patent rights to be the only person allowed to use the idea for commercial purposes for a given period of time. Independent inventions are different from group or organizational inventions, since the inventing process in independent inventions is through the efforts of one person. When a person is working for his or her employer, he or she is most likely made to sign a treaty on the ownership of his or her patents in case of an invention at work. Infringement is a very unethical act that is punishable in a civil court of law. An infringement case is whereby an individual or an organization produces, sells, or conducts any commercial activity without a patented commodity or product during the patent period. There's different types of infringement. There's direct infringement and indirect infringement. Indirect infringement, it involves a person or a group of people taking advantage of the inventor's work by using it for a commercial purpose. In indirect infringement, a party uses other people's ideas that are similar with the accusing patentee's invention to come up with a product after acquiring license from the use of the inventor. In such cases, the accused infringer may be left alone by the court if and only if he or she produces the license and the product he or she claims to have used, in which case must have been used to come up with the product in question. Different nations have different provisions in the patent laws they offer to inventors in their land. The difference in the laws are in the terms of the requirements that a person seeking to get patent rights have to fulfill prior and after patenting his or her property. There's also a difference in the time limit that a patent is given to enjoy monopolizing the use of his or her invention for commercial reasons. There's also an evident difference in the cost of acquiring patents in different countries. In the developed nations, like in the US and some European nations, the cost of patents in terms of filing for applications and all the preceding processes is very high. Similarly, infringement cases are very costly, especially for the infringer. Patent issues have caused nations around the world to unite and form organizations to look into solving ethical issues. For example, the World Health Organization, the major pharmaceutical producer, have been urged to refrain from patenting their generic drugs for the good of the world. Now, Aristotle's ethical philosophy calls for humans to act on virtue to train their moral habits. People are compelled to act in different ways, in different situations, by the desire to achieve the ultimate state of happiness. Those who infringe the patent laws do so in an attempt to take advantage of other people's work to reach the ultimate state of happiness. It is by virtue of the greed in them that they choose to rip what they did not put any effort to develop. According to Aristotle, their action is voluntary, and their conscience is clear when they engage in the vice. They take a deliberate choice to infringe the law, and most of the infringers are always ready to face the consequences of their actions. Aristotle pointed out that some decision making may be guided by weakness of an individual's will. According to Aristotle, the aspect of moral virtue can be compromised by the greed to achieve happiness. The enforcement of patent laws attracts very many ethical issues that should be addressed from a personal level if they are to be fixed. In conclusion, patent laws are used to ensure that the intellectual properties of people in different jurisdictions are protected such that only those who come up with the specific ideas can use them for commercial purposes. Patent laws were introduced to ensure that those who invent new ideas and products get to monopolize the use of their ideas for a given period of time. There are many ethical issues that surround the implementation of patent laws. Critics view the law as selfish. According to Aristotelian ethic theory, people should focus on doing what is good through selflessness and sharing instrumental goods. Thank you for listening to my presentation, and feel free to contact me with any questions you may have.